Good morning, all in the room. Let me reconvene this, our 8th meeting of this Joint Select Committee on the Private Security Industry Bill 2019. Let me take the opportunity to quickly welcome the Association of Security Companies of Trinidad and Tobago, the Estate Police Association of Trinidad and Tobago, and Amalgamated Security Services Limited of Trinidad and Tobago. And I invite you in that order to introduce yourselves for the record. Thank you.
Good morning, Chairman, members of the committee. My name is John Aboud, and I'm Chairman of ASCOT.
You.
Good morning. My name is Imsha Mohammed, and I am the Vice Chairman of the Association, ASCOT. Thank you.
You. EPA.
Good morning to all. My name is Darren Carmichael. I'm a member of ASCOT.
Thank you kindly.
Derek Richardson. I'm the president of the Estate Police Association.
Thank you, sir.
Good morning. My name is Richard Rupnarayan. I'm the Education and Research Officer of the Estate Police Association.
Let me, yes, sorry.
Good morning. I am Michael Aboud, Chairman of Amalgamated Security Services.
Thank you very much, gentlemen. I would like, yes, oh.
Good morning, Pamela Hussain, Chief Executive Officer, Amalgamated Security. Hi.
Good morning. I'm Brian Ramsey, the Regional Development Director at Amalgamated Security.
Okay, thank you all. I think we got it here now. Right. I am Fitzgerald Hines, Chairman of this committee, and I'll ask my colleagues to introduce themselves, starting on my right.
Good morning, everyone. Stuart Young, Minister of National Security, Minister in the Office of the Prime Minister, member of the committee.
Good morning, everyone. Nigel Lefruitas.
Good morning, Clarence Rambarat, member.
Morning, Brigadier General Ansel Antoine, member.
Good morning, Saddam Hussein, member, Opposition Senator.
Good morning, Independent Senator Vavandi Alsing.
Let me take the opportunity to specially welcome and recognize the presence of the officials of the Office of the Chief Parliamentary Counsel and the Ministry of the Attorney General, who have been central to the work that has gone before. Let me indicate as well that this hearing is being recorded and will be broadcast at a later time, subject to the agreement of this committee, on the Parliament Channel 11, Parliament Radio 105 FM, and the Parliament's YouTube channel, ParlView. The objective of this interface today is to provide an opportunity for you as key stakeholders, again, because I'm satisfied that we had some interface before, to provide or to proffer some of your thoughts and your views on the matter of the Private Security Industry Bill 2019. When we invited Amalgamated, we did so largely on the basis of the fact that you, Amalgamated, being a major player in the industry, had not by then submitted a written response to our request for written submissions. We have since received them and acknowledged receipt of same. We are mindful that you were involved in some of the interfaces we've had in the preparation of this bill, and of course we've had submissions from others. And on that basis, today, with the benefit of all that we have heard of each of you represented today as stakeholders, we would want to get from you some very specific matters that you may wish to raise. In those circumstances, against the backdrop of what we've had before, I will now invite the ASCOT to make any specific comments in relation to the bill, as we have invited you here so to do. We are in your hands, and we thank you.
Well, thank you, Mr. Chairman and members of the committee, for the opportunity to come before you to discuss this very critical bill for the industry. At the onset, just allow me to say that this has been going on since 1994. We've had maybe 3 or 4, at least, versions of an attempt to have a bill passed that will help regulate the industry. And to date, unfortunately, none has seen the light of day. Having said that, I want to start off by saying that ASCOT and the industry generally is in support of government attempting to regulate, regularize, improve the state of this private security industry in Trinidad and Tobago. Unfortunately, it's about 40 years too late. From the point of view of this industry has been evolving and developing for the last 60, 70 years, and now it's perhaps arguably the largest industry in Trinidad. Depending on who you ask, employment ranges from anywhere from 20,000 to 50,000. You ask anyone how many companies exist in Trinidad, quite honestly, as the association, we really don't know. We know how many members we have, but there are a lot more outside there that we don't know. So we welcome the opportunity, and we applaud you, Chairman, for championing this cause. Having said that, we have some very, very serious reservations about how this bill has been put forward, with all due respect. We would like to divide our concerns into macro concerns and micro concerns. The macro concerns are overall concerns that we have that I would like to share with you just in point form. And then you have the micro concerns, which is essentially how is this bill going to actually function in real life. There is a real life to this piece of legislation, and I do not believe, with all due respect again, we are in full support, I do not believe the drafters of this bill have had a proper understanding of how this industry works, particularly 60 years later. And an attempt to regularize it and to get it in shape could be very traumatic and could cause grievous bodily harm to the industry and to many, many people working with the industry. And I certainly don't think that this is the intention of this bill. So having said that, we have some key areas of macro concern. The first area of concern for us is that we do not see why the Estate Police Association, who presently represent the estate constables within the industry and outside of the industry in terms of proprietary, all estate constables are represented by the Estate Police Association. Now, we are of the view as an industry that we have been working with the Estate Police Association for a number of years. It hasn't always been nice. It hasn't always been comfortable. They have their job to do. We have ours. But the reality is that the association has all the institutional understanding of this industry. The executive are made up of security officers of various ranks within the industry. So when you sit down and you sit down to negotiate terms and conditions, wages, or whatever it is you're doing, there is an understanding of where the industry or the company is coming from, and there is a more likelihood of an agreement. So, our position is that we would certainly wish that you would reconsider removing the EPA from controlling our estate constables. We feel that there is need for that institutional memory, particularly over perhaps a transition period. That's number one. Number two, we view with great concern the bill omits completely the registration of proprietary security and MTS from this bill, and we question why. Proprietary security and MTS perform proprietary security. Well, we all know what that is. An organization has a security department that governs the security of that company, say Lever Brothers or any of the big companies, and the roles and functions that security department or that proprietary security does is exactly the same roles and functions that my security officer does, which is the protection of life and property. The liabilities of my officer is the exact liabilities of that proprietary security officer working for that organization. And we question as to why these organizations do not have to register their security departments with this new authority that is going to be formed. We feel it is critical. They have to conform to all the insurance policies, the limited, the public liabilities, everything that we do in terms of protecting our officers and protecting the general public from our officers, they should also have to do. And so we don't know if it's an omission, but certainly we would want to strongly advocate that every organization or person that employs a security officer must be registered with this with this board, because the functions are the same. Why is MTS omitted? MTS is a big player in this game. They have thousands of officers, they guard schools, they guard government ministries, they do everything. What makes an MTS security officer any different to an amalgamated security officer? Only the uniform. That's number two. Number three, there seems to be, the bill completely omits all people or personnel that work in the electronic security business. To me, that should be a greater concern to this committee than even a security officer, because you have people who go outside here and install alarms in people's homes. They have to put codes in those alarms, and therefore some degree of registration of the people, some degree of licensing of the people who install these alarms and these security systems should take place within the ambit of this board.
We call them support services.
Well, support services for us is drivers and cleaners, not elect. These are technical people. These are technical people.
Please. Press on, I'm sorry.
Okay, yeah, no problem. The other issues we have is we are not satisfied that the bill adequately addresses the insurance requirements of security companies. In other words, we feel that the bill should be very clear on the amount and the type of insurance coverage that companies should have to protect, again, its employees and the general public. Whilst the bill does talk about it, it does not adequately address quantitatively how much insurance, for example, how much public liability a security company should have, what level of workmen's compensation, what level of medical insurance, what level of life insurance. These things, I think, should be very clearly defined, and all security companies should have to conform to them before a license being issued, including proprietary and including MTS. The next issue we have, sir, is the composition of the committee, and you may correct me on this. We are gravely concerned that the committee that will run this board seems to be void of any security, any members of ASCOT or security company representation. It does talk about security experience, but we feel very strongly that the board must have a significant participation from the industry, only because we will be able to guide the proposed chairman, who I'm sure will be very competent in his field of endeavor and of higher integrity. But once again, the industry is very peculiar, and certainly the chairman will want to listen at least to the opinion of the stakeholders, of the people running the business, and then make an informed decision. And we feel that there should be a very strong presence of ASCOT or security company representation on this committee, so that adequate representation is made and the chairman and the committee does not make an error in a decision or a regulation that can result in severe harm to the industry or to the employees. The industry, Mr. Chairman, members, provides a very significant contribution to the social fabric of this country. If we're employing 30 or 40,000 people, that's 30 or 40,000 people with different skill sets. Not every security officer is Kojak. You have security officers that are trained to deal with certain jobs, and you have other security officers who are trained to do basic functions. Any dislodgement of these people will exasperate the issue of unemployment, and I dare say cause more social problems than it solves. So we are of the view that whatever you do should be on a phased-in basis. Registering 30,000, 40,000, God knows how many people into and ensuring that they conform to a certain minimum standard is going to prove extremely challenging. So we want to respectfully suggest that that part of the bill, in terms of registering the security officer, should be on a phased basis, not 18 months. That's not good enough. We figured maybe 3 years or 5 years. Give people a chance to register, give people a chance to perhaps attain there may be certain qualifications that are necessary, like reading and writing, that some of our officers may not be very competent in. What do we do with these people? Send them home? They perform an excellent job doing the job that they do, but there may be certain skill sets that may not be available, that they may not have, and that's a reality that we need to look at and see how best we can grandfather these people into the into this.
Your point is taken.
Right, okay. The industry is also very concerned about the fee structure. You talk about fees, there's no objection to paying fees, but it's bland. Is it fees based on a structure, a size company? How is the fee, how much fees, and how is it going to be structured? The members of ASCOT are concerned because we represent about 80 or 90 companies from the smallest to the biggest, and therefore there is a concern that the fees should be reflective of size. Chairman, I think I'll pause at this point.
List?
Well, for the time being.
Thank you very, very warmly. In which case, you having spoken on behalf of ASCOT, we can now move to the EPA for your comments.
Thank you very much for the invite to address this Joint Select Committee on the Private Security Industry Bill. Of course, we represent the Estate Police Association, a creature of statute. The bill, our organization, of course, would have been in existence since the bill the Act goes through 1906. and the association was then incorporated into the Act 1950 and actually became operationalized in 1951. It must be noted that up until 2006, the association was responsible for the terms and conditions of all officers in the security industry, inclusive of those that are in-house, as we could call it, ASCOT constables, and those who do not hold precepts, until a judgment of the court decided that that we will only represent those persons who hold precepts from the Commissioner of Police. The background also is that, that the Supplemental Police Act 1502, essentially at that point in time was created to see to the needs of the private security industry and support the government and the state arm, the police service as such. So included in that bill, you had some things like rural police and special ASCOT constables, which have now been redundant, right? Our position on the bill as a present is that we support all attempts to regulate the industry. We are on record over the years as having had serious issues with how people get into the business in the first place, right? How they're registered, how they carry about their business, and how they treat their employees, most importantly. So we are mindful of that, and we are thankful that that this has come to this point. However, we know that there are a number of attempts, as been indicated by Mr. Aboud, to have this position where we are today. We are also mindful that in 1995, there was in fact an act that passed through both houses of the Parliament, but it was allowed to lapse, right? We have looked at that act and we recognize that there are some 95% probably of that act is here today, right? So we are saying that that 1995 bill that was passed through both houses mirrors this, right? Is something that we should really probably look into, seeing that it has already passed through both houses. Now, we are also of the opinion that the jobs that are stated in this bill mirrors that of an estate constable who carries a precept. The difference, what has been happening in the industry is that you have estate constables who carry a precept. So we are hearing here in this bill, you have a license. And to our thing, a precept is also a license, right? And that gives you certain powers and immunities, right, which goes with that. Now, when you take that away now from those persons who are functioning in the industry, in the private security industry, so those private security companies now will lose the estate constables. They will be taken away from the private security industries, right? So what is going to happen is you're going to lose a number of well-trained people who have been so certified by the Commissioner of Police to carry out the functions which are very similar to that. In fact, the Act speaks to the constable being able to have all powers and rights and immunities of that of a constable in the police service. So we can take before the courts of law. We do assist the state police in a number of areas. Where I am from, and where previously in the industry, we would have gone with the police on raids. We can get search warrants, we are under the guise of the magistrate, or the guidance of the magistrates. So that is a major part of it that will be taken away. It will also place a burden on the police service now, because when you take a number of those officers out of the system, who cannot take the actions that are a constable, then you have to go to the police now and have an added burden of investigating and taking these offenses before the courts, right? Now, it is also going to have a severe impact on the association where membership is concerned. Because when we look at the numbers, when you take out the private security industry from our membership, right, it leaves us with bare minimum, right? What we've recognized over the years is that there has been, in the in-house security and the proprietary security thing, there has been private security already resides there, in addition to the private security and proprietary security already reside with what we call the hybrid system of things. We've seen that being eroded over a number of years, and we have a serious concern over that because it takes away a number of prime jobs from the industry. The industry is by and large a very low-paying industry, and the terms and conditions which we have been hammered out between the owners and the Estate Police Association. Now, when you remove that without any form of representation, then those things will be lost. Those gains will be lost. So it will be difficult. I know people can say that somebody is free to choose a bargaining body, anybody of the choice. But what we know that it is very difficult to do so. To get a majority representative body in any one of those companies will be a very difficult proposition. And it will leave a number of people, but only if there is an issue with employment, and they will have to go through the judicial review. They have to go to the High Court, and that is a very expensive thing. And we are propagating here that this bill can, the things that are in this authority can fit into the Supplemental Police Act. If we revamp the Supplemental Police Act, let's look at the act in the first place, the Supplemental Police Act, and let us place the things that we want to place there, right? Let us revamp the Supplemental Police section into a division of the police service so that they can administrate the things that we want to do here, right? Within that, the ambit of the Commissioner of Police. Let us retain the precept. Let us also retain the terms and conditions that those persons would, in the industry, would have had over a number of years. So to take that away from someone to go into a thing where they have to negotiate private contracts, some of them would not be able to even negotiate a proper contract, and would be left to the whims and fancies of any employer who has the resources, right, to hoodwink, as the case may be, any person that has signed any contract. And we've seen a lot of it where some people have been coerced into signing private contracts and to, frankly, sometimes even to leave in the association to do certain things. So those are our main concerns as it pertains to this. We also have a concern that in the Act, there is, you do not carry a precept, but you can carry a firearm. You do not have the powers of arrest except under common law, but you can carry a firearm. We think that needs to be addressed, and we think the way that needs to be addressed is through the Supplemental Police Act and going into the Supplemental Police Act first and revamping it right there.
Thank you very, very much. Thank you very much. I will now ask the amalgamated representative for your specific comments in relation to the bill, bearing in mind that you have issued a written submission, but you...
Thank you, Chairman, and good morning, everyone. Well, we went through the bill in a very detailed form, and in our submission, we itemized all our areas of issues. There are several common issues that were raised by John and the EPA. At the end of the day, we welcome the need for a regulatory body in place. We believe in the oversight. We have, in our own way, adopted a number of different standards and certifications internationally so that we recognize the importance and the need for an organization such as ours to survive in a security environment, that we need to ensure that there are adequate standards, especially when it comes to training, when it comes to providing the resources, the human capital, with the right environment that they can blossom in. So that, am I required to reproduce what I have said? No.
No, if you have anything you would like to amplify, because we have what you have said in writing now.
Correct.
If there's anything you would like to amplify or elucidate, or any fresh point you would like to raise, that's what our interest is.
I would like to reiterate what was said in terms of when this legislation comes into force and in whatever form or fashion that it does come into, it is important that it is adequately funded and staffed, because if that is not put in place, then all that we are wishing for here would not materialize in the way and the fashion that we want it to. There are not a lot of people in the industry, and at the end of the day, if enforcement is not going to be in place, then a lot of things will still go amiss, and the purpose of the legislation and the oversight will be lost. An element of the bill that I believe is not adequately covered is there's no mention about a security officer. If you look at Schedule 3, it's describing a number of different types of services or categories, but for whatever reason, there seems to be no mention of a security officer. So a company that is providing a BATO security officer, this bill doesn't cover them. Now, I don't know if that's an oversight or, so that will be a major point to bring out, so that we need to look at that. And then when we talk about insurances, in public liability insurance, unless you have the specific caveats included, general public liability does not cover false arrest, does not cover actions of an officer, and we think that just using the term public liability is inadequate. It should make reference to including these additional statements within the policy.
Could you rehash that for me, please, so I can?
Which one?
The point you just made.
About insurance?
Yeah.
Okay. Fundamentally, public liability insurance, what we call it general public liability, does not cover claims for false arrest, claims that are involving abuse, use of force, and so on by officers. It's a special addition that you have to include in the public liability policy requirement. So we're saying that the bill should be specifically mandating that those be included and not just use public liability as a general type of cover, because you can take out public liability, but at the end of the day, it would not give you the cover that you really wanted to cover. Right?
Point
So
taken.
special endorsements is what you refer to.
Thank you.
Drug testing and background screening is a big element of this industry, and the bill fails to talk about what are the items that we want to test for, whether it's a 2-point test, it's a 3-point, 7-point. It just talks about drug testing, so that you could test for marijuana and don't test for cocaine. And at the end of the day, you have an applicant who will have qualified through the drug test, but only because he's passing one component of the drug and not all, so that it is important to make a decision about whether you want it to be 3, 4, 5, 6, or 7-point. So these are kits that come that are designed, so a 2-point is marijuana, cocaine. A 7-point is what we use in the energy sector that covers a much larger array of drugs. So that we're saying that is something that you need to look at. And when we talk about random testing, there is no specification about what percentage. So if you say that an organization must do random drug testing and I only do one person randomly a year, I'm meeting what the bill is saying, when it should actually be a percentage of your workforce. So whether it's 8%, 10%, 15%. So that is something that should be also
Stipulated.
Stipulated, yes. In service types, we left out aviation security, and I'm identifying that specifically because in aviation security, there are some mandates of training that is not typically required in the everyday supply of security personnel. And therefore, it has to be looked at and be considered. And it forms a problem when the bill talks about if you're in violation and you're suspending an organization's license, which now precludes him from being able to supply the services to his client. That client is unable, in a moment's notice, or within a week or 2 weeks, to be able to replace, because what is involved in training people, for example, in aviation, is a 3-week cycle. So that if you impose the law and you suspend a license or you revoke a license, the client, we're not talking about the company now, what situation is the client going to be in? Because let's take Caribbean Airlines. If for whatever reason you suspend the supplier of security for Caribbean Airlines, how do they continue to operate? Because they have to meet certain security requirements in terms of presence of people that must meet a certain standard of training. That will become an issue. So you have to factor in that there are certain circumstances that simple cancellation or revocation cannot just take place in a moment or an instance of time. There'll be a significant impact on some institutions. So that is something that we're saying that you need to look at. We want to reiterate the importance of the separation that the bill seems to want between security services that are being proprietary supplied to government agencies or quasi-government agencies against contract security firms. And if we're talking about regulation and standardization, it has to be across the board, right? And the movement of labor occurs between both sides so that we're licensing an individual, but we're not licensing the department that is running the individual, and therefore things don't always happen at the level of the officer. It also happens at the level of supervisory from management, from that level. So you need to make sure that the standard covers that, takes into consideration that. Generally, internationally, there's a whistleblower requirement. So we're not seeing any specific mention for whistleblowing, and the bill should factor in that and should make reference to that, tie it in with, somewhere within the general laws within Trinidad. And we're also looking at the license. You talk about the licenses being issued to an operator, but not all operators operate in every sphere of the security industry. And we're saying that the license should actually be listing out the categories in which you're entitled to operate. So if I get a license to operate as a private security organization, I should not be able to get into electronics on that common license. The criteria, the requirements will be different, and therefore the license should not be a general license, but one that actually delineates the actual category of service or products to which you're supplying. Also, when we talk about a licensed person being suspended, what does that mean? Because suspending somebody, you haven't actually determined whether they're guilty or not. Does that mean that you're removing him from his ability to earn? So that we're also saying that when we talk about suspension and the reporting of suspension, the volume of activities that the regulatory body is going to have is going to be tremendous. So if you're not properly staffed, you're not going to be able to handle when a person becomes suspended. So that we are saying that maybe the bill should cater to what type of suspension or for what length of time a suspension is. So a person who's suspended for 1 day, maybe that is not required to be reported, rather maybe a person for 7 days. And I'm just suggesting numbers for the sake of clarity. I think basically those are the important points that I would like to re-highlight, and then my document clearly identifies all the other pieces of information that should be considered. And I use the examples and the explanation as to why, in terms of the thinking of why we would like to see something adjusted or changed. Right, and the last point would be issuing of a license to a security officer. The process between hiring, training, and waiting for this license is not going to make sense for the industry. Our people, they come to us for a job. So we hire them, we do the background check, we do the screening, and then we put them into training. The license is taking 60 days, 3 months maybe to come. What happens to that person who's seeking employment? What do they do? In other jurisdictions that we operate in, there are legislation that says a temporary license is issued for a 3-month period, after which you could revoke or you could then make it a permanent license.
Which jurisdictions, if you
Jamaica,
have it on your head?
Jamaica would be, that has that. So we're suggesting that maybe there is some period, that gap between you making it official that allows the person to be able to be trained and start to work while you're processing it. But you could always revoke if at the end of your process is not meeting your requirements. Thank you.
Thank you very, very much. Well, we have benefited from your comments. Just for completeness, if there's anyone else in front of us who would like to make a specific point on a matter that has not yet been raised, we'd be very happy to hear you. Thank you. Representing?
Imsha Mohammed, I'm representing ASCOT. On a personal basis, I'm the Managing Director of Imaging Security, but I've submitted separately for that. Today I'm here as ASCOT.
Thank you.
There are a few points that our chairman has been quite comprehensive, but there are a few smaller points that I wanted to bring to the committee's attention.
Separate and apart from what he has raised?
Yes. In clause 13.1 of the bill, we ask that which lists the duties of the board, the appointed board. We would ask that more attention be paid, or a clause inserted that will allow the board to take up to handle the investigation of people who are not actually following the bill. At the moment, who handles people who do not follow the bill? People who hire companies who are not licensed. There's no general sense. Maybe the police do, but we would ask that the committee and the inspectors, the board and the inspectors be allowed to handle investigations or reports of people acting in breach of this bill.
Well, we have inspectors, we have a system.
No, but it's not listed specifically. There's a general thing, because the inspectors are generally targeted at the companies registered and who are registered with them to meet the requirements of the bill.
And to ensure that the law is carried out in the provision of security services. That means if someone is operating outside
I am sure that, but what again we are saying, perhaps that could be made a little clearer. We're not arguing,
okay.
But we
please
perhaps,
continue.
Yes.
Thank you.
In section 7070, which refers to administrative, there's a section which refers to administrative breaches which may occur when people are hired and fired. It refers back to clause 36 and 37. Yeah, which are where the companies registered with the authority are supposed to provide information. There seem to be rather prohibitive fine. There's a fine for the directors of the companies, there are fines of 100,000 and imprisonment for 20 years for misfiling of papers. This seems a little bit prohibitive. Yeah?
Okay.
Section 7070.
70 what?
7070. 77, sorry. 77. Yes.
Okay. Right, okay. Clause 70, just a second. Clause 70, subsection, subclause.
Yes, sir.
Right. Let's get it right.
Let me just get it right.
Clause 70 doesn't have a subclause 7.
So 1, 2, 3, sorry. 72.7. I am sorry. I apologize.
All right. Thank you so much. Please proceed.
All right. But what I'm saying is, the fines for a misfiling of a document or late, a 1 month, because I think you have 1 month to submit if somebody's promoted. And if there's a fine that is 20 years and $100,000, if my clerk misplaces a document, seems a bit extreme.
All right, point is taken.
Yeah.
Yes.
And I just wanted to reiterate the point Mr. Aboud made, which
No
is the
need,
last
no
one.
need. He made it quite adequately, I assure you.
Fair enough. Well, then I think that is my little points that my chairman did not cover.
We are most grateful to you,
Thank you.
Mr. Mohammed. Yes, sir.
Yes, good day.
EPA?
Yes,
Could you
EPA,
identify yourself?
I'm Richard Rupnarine, the Education and Research Officer of the Estate Police Association. Sorry. The association opposes Section 5 of the bill, as employers are claiming that they cannot find suitable persons to employ in the private security industry, and there is a shortage. The Section 5 ousts 14 categories of employees from employment in the industry. In this day and age where persons may have to seek a second form of employment to supplement their income, the association does not see why these persons who could be easily trained or are trained to work in the industry to be excluded from working in the industry.
Okay.
With respect to the composition of the board, the association believes that it is deficient, and the inclusion of a member from the Occupational Safety and Health Authority, the Equal Opportunities Commission, and the Estate Police Association would benefit the board, as these members would be able to give their expertise to the industry in areas which traditionally are deficient in terms of labor relations for our employees and members. With respect to the authority, there is need to increase the scope of its functions. Firstly, to investigate matters related to labor conditions within the security industry and make recommendations for the correction of deficiencies. To investigate matters related to business and the award of contracts and make recommendation for the correction of deficiencies. To establish an Office of Economic Research similar to that of the Industrial Court, as this would aid the authority in its functions to correct deficiencies in the industry. The establishment of a library. The inspection of work sites and facilities to ensure that safe and humane working environments are kept, and a system of fines to ensure compliance and deter bad practices. The establishment of standards for all personal protective equipment and a system of fines. And the establishment of standardized procedures for natural disasters. We envision that the authority may be very instrumental in aiding the security apparatus in the future in terms of evacuation of personnel in terms of natural disasters, and we'd like to see that solidify into policy. The association believes that with respect to the authority itself that governs the industry, the staff should be employed consistent with good industrial relations practice and with the minimalization of temporary employment, so that the contracted worker would not be deprived of the benefits of a permanent employment, such as a pension plan in future. The bill proposes to allow license persons that have been previously convicted of offenses. It's difficult to understand how any person in prison for any period of time could be employed as a security officer, a special security officer, or serve as a director of security organization. And perhaps that should be reviewed. With respect to firearm, the bill does not omit or exclude foreign nationals from carrying firearms. The only provision is that when the company may employ SOs and SSOs, and upon the recommendation of one of the directors to the Commissioner of Police, the person would be issued with a FUEC, a Firearm Users Employee Certificate.
Mr. Rupnarayan, I appreciate your suggestions, but your submissions now resemble those that was already submitted to us in your written submission. And we have indicated at the top of this discussion interface that we have notice, we have acknowledged notice of those comments. So there's no need to rehash them at this point. We take notice of them in your written submission.
Very well, sir.
Thank you very much. So we have members, we will, having heard the submissions of the stakeholders today, we will take into account, we have recorded in fine detail all that we've heard. We will treat with every one of them, and of course, these are very public consultations. So you will, in that sense, and if we find it necessary to ask you to return for further amplification or to identify an issue or two with you, we will certainly do that. But I give you the assurance that we have benefited greatly from your submissions here today, and we will take all that you have said into account.
I think a couple of us wanted a couple of clarifications.
Yes. If there's, I mean, I want, you know, what I want to be able to do is to really seriously analyze every submission, and an immediate response from the committee might only touch a small aspect of it, may not grasp the whole of the ideas that have been put. So, members, if you have some specific things you would like to clarify also at this juncture, let's do so. Mr. Richards.
Thank you, Chairman. I think it was Mr. Aboud, as Chairman. You referenced the fee structures, and do you have a particular idea in mind in terms of what you think the fee structure should be based on, whether it be revenue or size of company in terms of number of officers, etc.?
He did say size.
Wait, but he didn't say size of revenue or size of...
He said, I gather that you said size of company.
Size of company, and by that we were referring to size of, in terms of number of employees.
Yes.
But that's a direct function of revenue.
Yes.
Also, in terms of the, I think it was Dr. Aboud mentioning the issue of those companies that provide installation of electronic or surveillance technologies, and how that could or should fit into this, given the fact that, well, then you may have to register TSTT as a security company. How do you see it working? As a separate security provision company, and should be under the ambit, in your opinion?
Well, I wouldn't define it as a security company, but the department that is handling that aspect of the security service as a third party, I mean, they're selling that service. So it's not a service that's also been internal. They are actually selling electronics to third parties. So therefore, they should be able, or they should be meeting the same standard that the external companies have to meet. So the regulatory body has to establish some criteria.
And in terms of the whistleblowing, is your consideration for internal whistleblowing or?
Whistleblowing is both kinds, is wherever it comes from.
So how does that conflict with confidentiality clauses that's contained in the bill itself?
Well, the whole purpose of providing protection for whistleblower is to allow him that ability. So that we have to marry it to the legislation, or if we have legislation that covers a normal whistleblowers, to incorporate it within this bill.
But I think there has been a consideration, I can't speak for the government, of course, but of a general whistleblower bill in consideration. But as far as this is concerned, I'm asking if you think it is more focused on internal whistleblowing, so that employees who feel that the company is not meeting the standard.
Yes, well, it will start from that. So it'll be internal.
Yes, Dr. Monilal.
Thank you very much, Chairman. Just a couple of quick questions. I took note of the concern as it relates to the structure of the board that the association suggests that a representative be placed on the board. In the legislation, in the draft as we have it here, it says specifically a representative of the business sector who is not associated with the private security industry. That may have some benefit, but I think the concern is that you really want someone from the industry itself to participate. Is there any other group, whether local or international or so on, you feel could also support the work of this sector by way of the board, that can make the board more relevant to the realities of the sector itself, as opposed to just lawyers or as opposed to just representatives? For example, you have the Ministry of Labor. I'm just picking up the point because it went across presentations. You have the Ministry of Labor. Is it that in the Ministry of Labor, for example, Mr. Rupnarayan, I think, made the point, that you should specify that it should be an OSHA representative as opposed to a representative of the ministry? We also have a clause with 4 appointees. That could be anyone. Is it that you are suggesting that that should be more specific? First question. Second question, I came in when Mr. Abood was speaking, but I didn't hear from anyone any concern. I wanted to raise whether there are concerns with this role of the inspector appointed by the authority, coming to the workplace with certain powers and so on. Is the association, the companies and the experts at the EPA, for example, concerned with that? And how will that work in a practical sense? And what implications it has for security management and indeed the law? It may have been touched, but I just browsed through the presentation. I didn't see it amplified. And it was a concern that some of us at least had. Sure.
Thank you, Member. The first question, there is an organization within the Ministry of National Security called OLIP, Office of Law Enforcement Policy. Chairman, you may be probably familiar. That organization has spent a lot of time with private security. In fact, some years ago, we formed what we call the PSNC, Private Security Network Commission, which was under the auspices of OLIP. Mr. Renault, I think, was the man in charge. I don't know if he still is. And that organization has a fair amount of experience and expertise in terms of the security industry generally. Indeed, in one of the previous incarnations, there was a hope that this organization, this committee formed by the ministry, PSNC, would be the forerunner of this regulatory body that will oversee the industry, but it wasn't to be. So certainly I would say that they, if not on the committee, they could be advisors to the committee because they have a lot of experience. And with respect to the second part of that first question is that we strongly believe that yes, you need to get expertise in the area. So like in the Ministry of Labor, the OSHA person will be great. I don't know what they're going to do because it's too widespread. But certainly in terms of the experience, for example, let's take the OSHA person. So you have an OSHA person on that committee, and there is a job site that, and this is what happens in reality. There's a job site that the toilet facilities may be, I don't know, 500 yards away. I'm just calling a number. And I don't know what the rules are with respect to where the toilet have to be compared to where the employee have to be. So is it that that OSHA person is going to go on every job site to certify and check what happens? Now, we all have to follow the OSHA Act. And I mean, switching hats quickly. For example, in the case of Amalgamated, we have an OSHA officer that goes out there and checks, and many clients are not very happy about that because they are in breach. But but the same way you need an OSHA officer there, perhaps a person, you also need to have people from the industry who can advise this regulatory board, and I'm not even suggesting one chairman, I'm saying that at least 2 or 3 members of the private security industry should be part of that board to contribute. At the end of the day, the chairman and the board will carry its decision, but certainly let the decisions that are being made are made with the full knowledge of what happens outside there, so that the chairman can't say he didn't know, or the board can't say they didn't know, because they would have been informed as part of the discussions within the committee. So that's number one.
I must say, generally speaking, without getting into the details, because I have indicated we would rather consider in deep detail and with thoroughness your submissions before we respond.
Fair enough.
Generality, this law respects, acknowledges, and must run alongside all other laws in Trinidad and Tobago. Well, insofar as whistleblower is concerned, we do not have whistleblower law in the generality. So you've raised the matter in terms of the specific issue here. And so it is subject to all other laws, labor laws, OSHA, everything, okay? In addition to that, the board, as now constructed, has the power to be advised and to interface with any stakeholder to benefit from the experience in order to carry out the functions as mandated under this law. And there's a complaints procedure too. If someone has a complaint, there's a very detailed procedure for analyzing and interpreting and resolving those complaints, which might take into account some of the things you've just said. And finally, it may give you great comfort that Mr. Reno, the director of OLEP, was personally, along with Mr. Belfort, his second in command, involved in the preparation of this bill all the way through. All the way
Chair, with all due respect, this law and these regulations are going to be applied to a living business, critical in nature. So when you speak about having the ability to file a complaint or object, or I'm hearing time. In this business, there is no such thing as time. So with all due respect, so we much prefer the matter dealt with up front, so that there will be no need for X, Y, or Z to go to appeal.
At which point, I must tell you that one of the considerations we've had is the question of the potential for conflict. I mean, in terms of the board and its functions, and having among it the presence of active players in the industry, there was that issue for our contemplation. But again, we can't...
Okay, Chair, not to belabor the point, I just want to give you a quick example, and I don't mean any disrespect by it. In 2006 or 7, whenever it was, in one of the incarnations of this private security bill, I had the good fortune, myself and Imsha, we met with legal officers, I believe, between the Ministry of National Security and the AG's office. And there were 3 ladies, fairly young ladies, so they were the ones who were charged with drafting this bill. And we had a very fiery discussion, and because they knew everything about armored vehicles, and I knew nothing. But having said that, the issue came up, one of the ladies wanted to put in the legislation, and I'm just making a quick point, that she really didn't appreciate security officers suiting her when she was walking down Frederick Street. Now, she's right, it's disrespectful, but I turn around and tell her, so, well, ma'am, you have to put legislation for every male in Trinidad and Tobago, because that seems to be a cultural issue. The point I'm making is that there are realities that only people involved in the reality can share. And as a result of that sharing, a decision may be swayed one way or the other. And that's the point.
Your point is taken.
The next issue, quickly, with respect to inspectors, that's a point that we raised because we expressed a concern that the qualification of the inspector, as how we read it, wasn't good enough. We felt that the inspector should be a fairly mature and senior person, a retired inspector of police, or because this inspector has serious powers. He could come into an organization and destroy that organization by closing it down. Because once an organization, if the security company is closed down for whatever breach, it's hardly likely that that security company can recover reputationally. So we felt in the case of the inspectors, and I think we mentioned it in our submission, that maybe you could reconsider raising the bar a bit in terms of the quality, in terms of the quality, in terms of qualifications and experience and maturity of those individuals.
Thank you very much. Let me recognize, what name, sir?
Brian Ramsey.
All right. Yes, sir.
I just want to address the issue that you have raised about the question of conflict if there are persons from the industry on the regulatory body. You heard Dr. Michael Aboud make mention of Jamaica earlier, and the reason why is there are several countries in the Caribbean who already regulate their private security industry. Jamaica, Barbados, St. Vincent, all have, Guyana, all have regulations and require licensing of security companies. Jamaica has the largest private security industry in the entire Caribbean, and Jamaica has had a regulatory body for many years. And included in the Jamaican legislation is the point that the gentlemen have made before, that there is someone or more than one person from the industry itself on the board.
Okay.
I had the benefit of knowing one individual in particular who sat on that board for many years. And just in private conversation, he told me about his ability to bring to the board the realities. Very often, people will look at something and think that that is how it should work. And then having someone from the industry being on the board, as opposed to simply being someone who's called in to ask advice in a consultative type capacity.
Yeah,
There's more benefit to having the person. It may be, and I'm quite sure, after seeing all the stuff about Commonwealth parliamentarians and so on, I'm fairly certain that the committee may be able to interact with the Jamaican Regulatory Authority to find out how the question of conflict is handled. But the impression that I have is that if conflict does arise, it doesn't blow up. It is handled within the board itself, and it's not a major issue or major problem for them.
The point is taken, and we will take that and all other submissions well into account. Members, is there any other issue that any member would like to specifically treat with? Yes, Mr. Lee.
Just one for elucidation and clarity by Dr. Aboud. In your early part of your presentation, you mentioned about security officer, and either the definition is missing somewhere in the could you just, I'm a bit confused with what you...
I was referring to Schedule 3, and there was no mention, there was nothing defining what we call a basic battle security officer. So that my interpretation is that any company that is only supplying that is being excluded from this bill because it's not being covered in the schedule.
I assure you that that is not the intention and that is not the case.
Right,
and that will not be the result. I give you that assurance. Yes, Mr. Hussain.
There's one point Dr. Aboud would have raised with respect to the specificity of the licenses, and that you believe that it should be a general license because a company could an operator can just apply for a license and he's able to perform any security service.
Right.
Is this found I know you looked at Jamaica and things like that.
Yeah, you have licenses that are specific to what is the type of service that you're delivering. In fact, you have licensing that goes beyond that. It goes to the use of equipment. So that a security officer like in Barbados, if he has to use a bateau, he has to be licensed for a bateau use versus not having a bateau at all.
I give you the assurance that here too we have categorized the different types of services, and we will take that into serious account. So a person would not be able to travel wildly across the industry without the adequate regulation. Yes?
Final point for clarification, and to Dr. Aboud in particular. Have you seen anywhere in the area, in the region that you all operate, this notion of peace enforcement officer and close protection officer and so on?
It's not covered as how you drafted it, it's done differently, but in reading this present bill, I understood exactly what your intentions were in terms of categorizing the different classes, so that we didn't see it as an issue.
Right. Well, it appears as though we've had a very productive interface. I'm satisfied as chairman that we have, and it falls therefore to me to sincerely thank you, ASCOT, the Association of Security Companies of Trinidad and Tobago, and to thank you, the Estate Police Association of Trinidad and Tobago, and to thank you, Amalgamated, for both your written submission and your elucidation here today, and to specifically thank every one of you as individuals who made a worthwhile contribution to our contemplation in the matter in front of us. I would like to thank you and permit you an opportunity to make a safe return to your specific workstations and continue to contribute to the development of this land, giving you the assurance that we'll take all that you have said into account and we'll respond in terms. May I thank you very much. Thank you. Thank you. And this meeting is therefore suspended for that purpose.